modification application by Yarmouth Town Council. I'll just do introductions. I'm Councillor Jeff Brodie. I'm the Vice Chair of the Appeals Committee, and I'll be chairing this morning's meeting. On my left is Councillor Karen Lucioni, and on my right is Councillor Martin Oliver. We constitute the subcommittee. We also have present from our legal department, Jodie Gibson, from our Democratic Services team, Sarah MacDonald. We also have Mr. Darrell Clark, who is the Rights of Way Manager, and I offer my welcome to Councillor Rodney Colbert from Yarmouth Town Council, who are the applicants. And that fly that's been in here for weeks is still trying to attack me. But the
date was Tuesday the 30th.
Oh, sorry, got the wrong date. Sorry, apologies. Sorry, I'm looking at the minutes of the last meeting. Sorry, the date is the 30th November. Apologies for that. Okay. That's the procedure. I will go through shortly, but we'll just deal with the formal business first. The minutes of the previous meeting held on the 9th of November 2021, are they agreed as the correct record? Yes. Anybody, you're not against, Karen? I know you weren't here, but you're allowed to. Oh, great. I do. I'll sign them off. Sarah, please. Thank you. Okay. Item 2 is declarations of interest, to invite members to declare any interest they might have in matters on the agenda. No. Either of you? No, I've got no interests either. Item 3 is the report of the Director of Neighbourhoods via the Rights of Way Manager, Mr. Clark, to consider the definitive map modification application. The procedure will be as follows. Mr. Clark will present his report. There will be an opportunity for both the committee and myself and the legal advisor to ask any questions. It will then be an opportunity for Mr. Corbett to present Yarmouth Town Council's case. There will then be an opportunity for the committee and myself and the legal advisor to ask any questions. There are no relevant landowners, but there are no landowners present, so we won't have to deal with that. So of course, we're within the pack of papers that we have, all 370 odd pages of it. There are correspondence from the people adjacent to the proposed right of way. There are no members of the public who are substantially affected present either. At the end of the formal part of it, I will ask Mr. Corbett to leave and Mr. Clark, and we will consider our view and get that to you. I think it's within 5 working days. I think it's that. But certainly fairly soon. Okay. All right. Exactly with everybody. Okay then. Okay, everybody. Okay. Thank you. Right. So we'll go over. Sorry.
Just about here.
Yes, you can. Okay, right, okay. So we will all use our microphones and we'll try and project our voices as loudly as possible. I can do louder than that, so hopefully I'll help you, Mr. Corbett, or Councillor Corbett. Okay, so we'll go over to the presentation of the report we have from the Rights of Way Manager and Mr. Darrell Clark. Darrell.
Good morning, everybody. So I'll start off with a quick introduction to rights of way and definitive maps. The definitive map and statement is the legal record of the island's 530-mile network of public footpaths, bridleways and byways. An application can be made to modify the definitive map under the Wildlife and Countryside Act 1981. Applications can be made to delete, add, upgrade or downgrade paths, or to vary the written description of a path in the document called the definitive statement. This particular application is made by Yarmouth Town Council and it seeks to add a public footpath to the definitive map. The Isle of Wight Council has a duty to determine the application on the basis of evidence as to whether a right of way exists or not, and the panel is to act in a quasi-judicial role in reaching its decision. This slide shows the general location of the claimed path. It's at the eastern end of the High Street at Yarmouth. The bold black dashed lines show the location of existing public rights of way recorded on the definitive map. And you will see that there are two similar paths to the west, which are commonly known as sea lanes. This slide shows the claimed path on an Ordnance Survey map with the High Street at the bottom and the sea at the top. The path is about 35 metres in length and extends to mean high water on the shore. And this is an aerial image showing the claimed path edged in red, and you can see from this the close proximity of various houses and buildings, which are more obviously seen in the following photographs. So this is a view of the start of the path at the High Street, starting on the adopted pavement. And this is a view at the start of the path looking down to the sea. The path is approximately 3 metres wide, but it does narrow to about 2.7 metres at about the position of the second larger drain cover shown in this photo. It then narrows to about 1 metre where it meets the shore. And this is the view at the end of the path. It's taken at high tide. I've added the yellow lines to show what is actually being claimed as the path. It does not include any land on the other side of the gate shown on the left, or any of the land on the seaward side of the yellow line to the right. The access to the shore, which is being claimed, is between those two areas, i.e. immediately to the right of the gate. The width there is no more than 1 metre. And here is that area again, looking down to the shore at low tide. There is a very large step and then a lower sea wall with about a 3 to 4 foot drop to the beach. So there aren't steps to the shore, although it may be the case that beach levels alter with tides and weather conditions, which will vary the height down to the shore. If you could take note of the fence on the left, as this will be shown on the next slide from a different angle. So you can see the fence here, and access to the shore is immediately in front of that. This photo was taken at peak low tide, and you will note that there is not a great deal of beach exposed. And this is the view taken from the shore, looking up the path. The 3 to 4 foot wall in the foreground, and then the large step up to the main section of the path. It's possible to climb up and down here, but it's not particularly easy. So this application is claimed to add that path to the definitive map. The evidence to support the application is use of the path by the public for a period of 20 years, and this is known as presumed dedication. Use of the path is evidenced in this case by the submission of 51 user evidence forms, which are set out in Appendix 6 to the report. The law and tests which have to be applied to the evidence are set out in Section 31 of the Highways Act 1980. The Council has fully investigated the application, which has involved full analysis of all user evidence, contacting user witnesses to clarify queries on the evidence, communication with affected landowners and evaluating their representations, site inspections and examination of maps and photographs. Full consultation has occurred with all landowners deemed to be affected by the application. The town or parish council would normally be consulted, but they are the applicant in this case. Councillor Peter Spink, the local member, and Councillor Jonathan Bacon, the relevant cabinet member, have both been consulted and have not raised any objections. The committee report was submitted to the applicant and all landowners for comment and no comments or objections were made. So I mentioned consultation with landowners, and there are 5 in all. This map is the easiest way of showing who owns what in the area. The red section is most of the claimed path, and this land is unregistered and an actual title owner cannot be located. In these circumstances, there is a presumption in law that adjoining owners own to the halfway point for the extent of their frontage. So the owners of the orange, yellow and blue land have all been treated as affected owners of the claimed path for the purpose of this application. Full details, names and addresses, etc. is set out in Appendix 4. The freehold title of the grey, green and brown areas is held by the Crown Estate, who lease each holding. Grey to a Mr. May of Yew Trees, green to a Mr. Charrington of Friars House, this is the yellow land shown as Florins, and brown to the Isle of Wight Council, which is basically the beach. This is managed by the Council's Commercial Services Department. All these parties have been consulted on the application and invited to comment and to provide evidence. The Crown Estate and the Council's Commercial Services Department have no objection to the application. Where other landowners have commented, this will be dealt with later when I cover landowner evidence. As already mentioned, the evidence lodged with the application is user evidence, and the basis of the claim is presumed dedication. In order to reach a presumption of dedication, a number of tests laid out in section 31 have to be satisfied. Namely, the use must have been brought into question, there must be a way over land, the public must have used the way for a 20-year period, the use has to be as of right, the use must not be interrupted, and evidence to show that there was no intention by the landowners to dedicate will negate the presumption of dedication. I will now deal with each of these tests. So the first test is brought into question. There must be evidence to show that use of the path has been challenged in some way, i.e. brought into question. The 20-year period is then counted back from that date. In this case, evidence shows that at the beginning of 2017, demolition and construction works commenced an adjacent property, which is now called Friars House. And during the course of that year, access along the claim path was restricted for health and safety reasons associated with those works. Barriers and signage were erected. It is considered that this restriction on the use of the claim path is what brought the public's use into question. So the 20-year period in this case is 1997 to 2017. The second test is the way must be over land. The surface and immediate subsoil of land is dedicated as a public right of way. It's not possible to dedicate a direction of travel. There must be a permanent physical feature that is capable of being dedicated. In this case, it's clear that there is land in existence, an actual permanent surface which the user witnesses have walked on. The next test is that there must be public use over the 20-year period. There must be sufficient use to bring home to a landowner that a right was being asserted against them and they had the opportunity to resist or interrupt. This use can be by local persons only. Use, trivial or sporadic in nature, which would not likely make a landowner aware of a potential claim, fails the test. Evidence of use by family, friends or employees of a landowner may be given less weight, as they can be thought of as having the consent of the landowner and not representative of the public. Actual acts of use for 20 years are required. use by different persons for periods of less than 20 years will suffice if, when added together, there is continuous 20-year use. In this case, there is evidence of continued use in the period 1997 to 2017, and this can be summarised by looking at the user witness bar chart. Unfortunately, the whole chart is too large to fit on one slide. However, to explain the chart, the names of the 51 witnesses is in the first column. The next two columns are for background information as to when use first started and ended. The next column confirms how many times a witness used the path in a year, and then along the top we have the relevant 20-year period. A tick confirms use by the witness in each year. The blacked out box is confirming no use. And this is the second half of the chart. The chart as a whole indicates a high number of users in the relevant 20-year period. Only 6 witnesses out of the 51 indicated no use during that time. All 45 users confirmed use for leisure purposes. Although the number of users is high, the frequency is low, and 10 of the users were unable to specify how many times per year that they used the path. However, it could be considered that the low frequency is explained by the path being a dead end. It's considered that you would only use the path specifically for the purpose of gaining access to the shore or the sea view. It's not the case that the path is a circular route or provides a link or shortcut as part of an existing route where a higher level of frequency would be expected. To summarise, the user evidence is considered to satisfy the test of public use for 20 years. The next 2 tests are that use must have been as of right and without interruption. As of right means use without force, secrecy, or permission. Use by family, friends, and employees of a landowner should be given less weight, as they may be thought of as having the permission of a landowner and not representative of the public. There is strong evidence of use as of right in this case, as the user evidence forms did not show any use by force or with secrecy. In respect of permission, only 3 of the witnesses refer to being friends with a landowner, so potentially less weight should be given to their evidence. However, as the majority of the path is over land which is not held outright by a title holder, it could be considered that they were not in fact using the path with a landowner's permission in any event. An interruption is a physical or actual interference which stops public use for a period of time. A single act of interruption by a landowner is of much more weight than many acts of enjoyment. However, the user evidence forms do not reveal any evidence of use being interrupted in this case. The final test is that there must be no evidence of no intention to dedicate by the landowners. Sufficient evidence to negate the presumption of dedication requires clear acts by landowners directed at the users to make known to them the intention to not to dedicate. For example, the putting up of private or no public rights of way signs, the locking of gates, or the lodging with the council of a statement known as a Section 31 deposit, which has the effect of a landowner stating that a public right of way does not exist. Such a deposit has not been made in this case. It's at this stage we consider landowner evidence. However, none of the landowners provided evidence which shows use not being as of right, or that there was interruption, or any acts which showed an intention not to dedicate. The only landowner representation was that of Mr. John May. He acknowledges use by the public and states that it's always been open during his 30 years of ownership, but considers that the path has not been a public right of way due to the actual land not being owned by the Isle of Wight Council. However, land ownership has no bearing on whether a path has become public by way of presumed dedication. And, for example, a considerable percentage of public rights of way on the island are not over land within the council ownership, i.e., most public rights of way run over private land. Mr. May also raised concerns based on health and safety, including a 10-foot drop at the end of the path to the beach and his own slipway which gets slippery, although this is gated off from the claimed path. However, none of the 51 witnesses referred to any risks or health and safety concerns in their evidence. Finally, Mr. May explained that he has a legal right to use the path with vehicles to gain access to his land, which must not be affected by the path being added to the definitive map. I can confirm that any lawful rights that Mr. May and any other landowners have over the path will not be affected by the recording of the path as a public right of way. So in conclusion, it's considered that the application meets the tests for presumed dedication under section 31 as a way over land is considered to exist. There is sufficient evidence of use by the public during the 20-year period. Use has been as of right. There has been no interruption in the use, and there is no evidence showing that landowners did not intend to dedicate. In cases such as this, the possibility of dedication at common law, as opposed to section 31, must also be considered. For dedication to succeed at common law, the amount of use and frequency must be substantial, and the landowner must have stood by, seen it, and allowed it to happen. The amount of use in this matter is insufficient for this purpose, and it's also the case that for the majority of the path there has not been an outright freehold title holder. Accordingly, it's considered that dedication on the basis of common law has not occurred. So to determine this application, the panel should come to a conclusion on the evidence as to whether a presumption of dedication has arisen, or what public rights exist or are reasonably alleged to exist, and should decide on one of the following options. Option 1, make an order to add the path described in the application to the definitive map and statement. Or option 2, reject the application and make no order. In reaching this decision, the panel must act in a quasi-judicial role. That is to say, the panel must objectively consider all the relevant evidence, taking advice of legal principles where necessary, and come to a conclusion on the balance of probability. The balance of probability test requires assessment of the evidence on opposing sides. It's a balancing act involving careful assessment of the relative values of the individual pieces of evidence and the evidence taken as a whole. The panel must disregard all views which are not relevant to the fact which has to be found. For example, the effect or desirability of the right of way, should it be found to exist. And that brings my presentation to an end. So thank you for listening.
Thank you, Mr. Clark. That was comprehensive. All right, an opportunity for any questions from the committee. Councillor Oliver, have you anything you'd like to ask?
Yeah, just a couple of clarifications. I mean, I noted during there was no landowner comments. You confirmed there was no landowner comments on the application. Car access, and as much as being able to use the land, I mean, it's only a 3 metre wide. You're going to struggle to get too much down there, but the car access is not that, it can only go down so far, I'm assuming anyways. I'm not sure why you want car access down there anyway, but would that still be allowed?
So I've just gone back to this slide. You see the larger drain cover. To the left and right of that, there are access to buildings, and I presume boathouse type buildings. I think it's quite common for the landowners to take their car down there to hitch up for their boats and things like that. And then you've got the big gate on the right as well, which does provide access to the adjoining property. But yes, it's not going to be a road as such, but they will be entitled to continue those private rights of way.
Sorry, Chair, as a follow-up to that one, with the actual maintenance of the path, where does that lie with? Who does that lie with?
So if I could turn to page 12 of the bundle, which is the legal implications of in the report. Paragraph 56 confirms that public footpaths and bridleways dedicated after the 16th of December 1949 are not maintainable at public expense. So there won't actually be any liability on the council to maintain that path. In reality, I suspect the Rights of Way Department would step in and make sure that there weren't any obvious trip hazards, for example, because if there were hazards which if the landowners or anybody else doesn't repair or we don't repair, it would mean we'd have to close the path. So we're likely to step in because we're not talking about a massive liability here.
Councillor Lucioli, Karen, anything? No? Just one question for me, Mr. Clark, in terms of car use. It wouldn't be unusual, I wouldn't imagine, for cars to use rights of way anywhere on the Isle of Wight on occasion. Would I be right in assuming that?
Like I said in my presentation, a majority of paths on the island are over private land, and the landowners have an automatic right to drive on those paths.
Right. Good morning, everyone. I'm, as you probably know, a town councillor, and I'm a town trustee of Yarmouth. The reason this came about, as was pointed out, that when this new house, they pulled a house down, decided to build a brand new house in place of it. We have a lot of that goes on in Yarmouth, a lot of rich people. And we suddenly found the lane blocked off. We then investigated, and we realised, from what reasoning I don't know, that that particular lane didn't have a right of way. The other lanes, there are 5 C lanes in actual fact. Bank Street is a C lane. You may not know it, but it's a C lane, leads to Piers Shore. And these were guarded by the men of Yarmouth, where they landed their boats and put them down over those small quays. So they've been in our use forever. I would have to take you back with a bit of history. Our town goes back to Baldwin de Redvers, Charter 1135, and these roads and lanes are part of our town, and as all locals say, we know that. When the borough was dissolved in 1891, the Isle of Wight Council of the day took over the roads, but for some unknown reason, they did not take over the lanes. And there are more than C lanes in the town, there are other lanes as well. And so literally nobody looks after them. But what we have done, with sympathetic householders down the other lanes. We've asked them to shingle the lane, which they've done for the town council, so they've actually made a decent lane. But all the lanes do not have ownership as such, because we, the town, believe they belong to us through our ancient charters. We have records of that. Love Lane, the one down, they tried to close it off at one time in 1824. It was taken to the magistrates at Newport, and it was found for the town it had to be kept open. The gates leading to the beach at Pier Shore were beaten down by the men of Yarmouth in 1877. We believe all these areas belong to us. That is why the difficulty is who owns the land. We believe we have ownership through forever. The looking after the lane was the fault of the council of the island at the time that never took over the lane. If any of you know Yarmouth, we have an area called Wheatsheaf Lane. I can remember when suddenly that was tarmacadam, because the council of the day, county council of the day, said we don't own it, but they had to do it because holes appeared in the lane and it got dangerous. And the whole of Yarmouth has been made up because it's such an ancient town with all these things that it's been oversighted. I'm pleased to hear that if there was any major problem that you would take over and perhaps fill the holes. The town council was quite willing, but we have a very limited budget, of course. Our precept's probably one of the smallest on the island. And the people of the town were extremely upset when they found that it was being barred off. We have lost one lane in the town, going back quite a few years when gates were put across. And at that point, the local town council didn't object or didn't know what they were doing. And so we considered that a lost lane, but it's a very thing dear to the hearts of the people of Yarmouth. And most of those applicants are born and bred Yarmouth people.
Thank you for that, Councillor Corbett. Would you switch the button off now for a second? Thank you. And thanks for that. I mean, it's interesting history, of course, and although I don't live in Yarmouth, I do know Yarmouth fairly well, and I'm sure my colleagues do as well. You know, as Isle of Wight Council, we do tend to know the island reasonably well. Now, the opportunity now is for questions from the committee. So again, I'll start off with you, Councillor Oliver. Martin? Nothing? Councillor Lucioni? I don't have any questions for you either, to be honest. I'll leave it there. Anything, Jody? No more questions. Yeah. Right. I think, Councillor Corbett, I think that was probably very interesting after the meeting, but I think it's fairly straightforward. What we have to decide today is to whether to make an order to add the path to the definitive map or not. You know, I mean, the ownership of etc. I don't propose to revisit the 19th century and what the Isle of Wight County Council did at that point. I think Mr. Clark has indicated if there was a significant problem, if we do make an order down here, his department would address it, which I think is pretty impressive, really, given the financial struggles that I know Mr. Clark has with rights of way. But we'll deal with what we've got in front of us now. Okay. I've got no questions of you. We have no landowners. So, and I think I've just read the rest of the procedure, which I only saw this morning, and it's slightly different from the last appeals committee I did, which was for education. You don't have to leave. We can deal with this here. There's nothing that can't be heard in the public interest. Do either councillor wish to say anything, make a proposal, or would you like me to do that?
To be honest. Sorry, to be honest, Chair, I'm quite happy with the proposal of, what we've actually, the recommendation which has been put in front of us, which is in view of the conclusion of paragraph 47, it's recommended that in response to the application, an order be made to add the claim path to the definitive map and statement on its public footpath. I can't see we've got any more to discuss, to be perfectly honest.
Well, I wouldn't disagree, to be frank. Councillor Lucioni, would you? I think it's an overwhelming case for us to make an order to add the path. I think the comprehensive report by Mr. Clark, all of the evidence, etc., that we were provided with, over 350 pages of it, which I went through at the weekend, and it's a cut and dry case as far as I'm concerned. There's nobody here to object. There's nobody wishing to make take an alternative position. So therefore, I would agree with that. Therefore, can we just formally all just on the proposal from Councillor Oliver, vote on his proposal that we make option 1, that we, in view of the conclusion at paragraph 47, it is recommended that in response to the application, an order be made to add the claimed path to the definitive map and statement as a public footpath. All those in favour, please show. That's unanimous. Thank you very much. So you don't have to wait for that. You've got your order, Councillor Corbett, and thank you for your attendance. I don't think there's anything else to do, so I will formally close the meeting. Thanks everybody for coming along. Cheers.